Are you a landlord or a tenant in Illinois? Do you want to ensure that you are following all the state's regulations when it comes to rental properties? In this video, I'm going to dive into the details of Illinois landlord-tenant laws and help you navigate the complex world of rental agreements. Also, a little disclaimer: if you need specific legal advice, consider talking to a lawyer or a real estate manager to answer any questions you may have. Is Illinois a landlord-friendly state? Illinois is not usually considered a landlord-friendly state since there are several restrictions for landlords and what they can do to lease their property. On average, tenants have more leverage than landlords. What does a rental agreement include in Illinois? According to Illinois law, Landlord and Tenant Act, a lease agreement is required for any tenancy that goes longer than 12 months. The landlord is allowed to use an oral agreement if they want. Therefore, it's important to have a written agreement for physical proof of anything and everything that was agreed upon. For more information on this, click the link in the description. Some of the clauses that most leases in Illinois include are name and address of the landlord and tenant, description of the leased property, rental payments clauses, security deposit clauses, and information about the person responsible for repairs and maintenance services. What are landlords' rights and responsibilities? These are a set of guidelines that every landlord must follow throughout the duration of the tenancy. The guidelines may vary depending on the landlord, but generally they work the same. Landlords have the right to collect rent payments when they're due, as well as use security deposits to cover damages that exceed normal wear and tear, unpaid utility bills, or unpaid rent. Also, the landlord has the right to evict their tenant if they don't comply with the lease terms. While Illinois law doesn't state any specific responsibilities for the landlord, they are expected to provide the tenant a habitable unit that complies with the local housing laws. Additionally, the landlord must provide required repairs within 14 days. If they fail to do so, tenants may make the required repairs by themselves and deduct costs from their rent payments. What are tenants' rights and responsibilities? The state law allows tenants to seek habitable housing, meaning that the property should be presented in good condition by the landlord. In case the property suffers from damages that exceed normal wear and tear, the landlord must provide repairs within a reasonable time frame. Otherwise, tenants may make the required repairs themselves or seek legal advice. Aside from being required to pay rent on time, Illinois tenants have to keep the property in good condition, provide any required repair service for the unit, do a regular maintenance service to the utilities, and not disturb other neighbors or tenants. Illinois landlord-tenant laws clauses. Landlords may choose to include as many clauses as they consider appropriate, as long as they are compliant with the state laws. However, there is a list of general guidelines that most leases include. Rent payment clauses. Generally speaking, landlords are allowed by state law to charge any amount of rent they consider appropriate since there aren't any rent control policies in the state. On the other hand, landlords can raise rent prices whenever they consider it appropriate, as long as they do it after the lease ends. Normally, landlords are not required to give any notice, but at-will tenants must be given at least 30 days of notice. Rent fees. There are a few limitations regarding late fees in Illinois. In essence, these fees must not be greater than $20 or 20% of the total rent price. If the landlord wants to charge rent fees to their tenant, they must include a clause in the rental agreement document. Grace periods. Rent is considered late if it isn't paid within 5 days of the due date. If the landlord wants to include a grace period in the lease, they must include a rental document clause. Security deposit clauses. A security deposit is mainly used by the landlords to cover any bills or damages that the tenant may have caused during the lease term. There isn't a minimum or a maximum amount of the security deposit that the landlord may charge, so it's assumed that they can charge any amount they consider appropriate. According to the landlord-tenant laws in Illinois, the landlord must return the security deposit to the tenant within 45 days of the date they leave the unit. If the landlord decides to withhold a security deposit partially, they must send an itemized list of damages to the tenant within 30 days of them moving out. In that case, the landlord has to provide the necessary repairs within 30 days. If the landlord fails to make these repairs, they must give the deposit back within 45 days of the tenant leaving. Otherwise, they might be sued by their tenant. The landlord may legally withhold a security deposit in those two scenarios. There's unpaid rent or some damages exceed normal wear and tear. Security deposit interest. According to the Security Deposit Interest Act, any landlord who has a property with 25 units or more must pay interest on any deposits held for a minimum of 6 months. In the city of Chicago, landlords must open an interest-bearing deposit unless the tenant is in owner-occupied buildings of the 6 units or less. If you want to check the yearly interest rate in Chicago, make sure you check out the link in the description. Lease termination and eviction clauses. Illinois tenants can terminate the lease after it ends. However, they must provide a notice depending on the type of lease. If it's a weekly lease, it's a 7-day notice. If it's a monthly lease, it's a 30-day notice. And if it's a yearly lease, it's a 60-day notice. The lease may be terminated early if there is domestic violence, unacceptable living conditions, early termination clauses, or active military duty. Regardless of the reason, tenants may be required to pay rent until the agreement ends, and they may not be allowed to fully break the lease after rent is paid. On the other hand, landlords may terminate the agreement for non-payment of rent, which is 5-day eviction notice to pay or quit, breach of lease terms, it's 10-day eviction notice to cure or quit, and criminal activity, which is a 5-day unconditional eviction notice. In the case of at-will tenants, landlords must give a 30-day notice before the eviction process happens. If you want your very own lease agreement template for the state of Illinois, or to see a full guide of the eviction process and laws for Illinois, click the link in the description. Housing discrimination. The Fair Housing Act and Illinois Human Rights Act protect tenants from any kind of discrimination against them based on their race, national origin, familial status, religion, sex, disability, and more. If the landlord is deemed guilty of violating either of the Illinois Human Rights Act or the Fair Housing Act, they may have to pay up to $21,000. Additional landlord-tenant clauses in Illinois. These are some clauses that aren't found in every rental document in Illinois, but they should still be considered by the landlord to promote a safe and healthy relationship that complies with the state laws. Landlord's rights to entry. There aren't any specific rules regarding landlords' rights to enter their unit, meaning that they may enter at any point of the day without any kind of notice. However, it's considered good practice to come to an agreement with the tenant on notification policies. It's important to note that landlords in Chicago are required to provide 2 days of written notice to the tenant before they enter the unit. In both cases, landlords can enter their unit at any time in emergency cases, such as damages to the unit, domestic violence to the tenant, or more. Small Claims Court. A small claims court in Illinois can hear rental cases of up to $10,000. Lock changing. If the county where the rental unit has over 3 million people living there, the landlord is required to change the locks after the term ends for security measures. However, the tenants have the right to request a lock change if they become victims of domestic violence. In that case, the domestic violence victim should send notice to the landlord so they can change the locks promptly. Following the law during the tenancy is the first step towards having a great relationship. If landlords and tenants are fully compliant from the beginning, the tenancy is likely to go through without any issues. It's crucial for both landlords and tenants to be well informed about Illinois landlord-tenant laws. By understanding these laws, you can create a harmonious and respectful rent relationship that benefits both parties. Remember, knowledge is power, and being informed about the regulations and rights surrounding rental properties will ensure a successful and stress-free experience. If you need any additional information, seek help from a lawyer or real estate manager. Thank you for watching this video. If you would like to see more videos like this, check out this video. Also, remember to like, comment, and subscribe. Have a great day.